Okay, the final paper of today, two authors, and I'm looking forward to hear from you. How will you present it? Different order, or divide the presentation? Yes. And yeah. Okay. Well, the floor is yours.
And speak into the mic. I don't think so.
Good afternoon. Yeah, good afternoon, everyone. We are Emily and Maranatha, and then we are actually undergraduate students in Professor Carty's international law class, and then we would like to thank Professor Carty for giving us the opportunity to present our paper in this workshop. The topic of our paper is the hazards of translating Wheaton's elements of international law into Chinese and cultures of world order lost in translation. William Martin's Chinese translation of Henry Wheaton's Elements of International Law in 1864, that is Qing Dynasty, was the first comprehensive and systematic translation of a Western legal text in China. Our research conducts a close analysis of the Chinese translation of Elements of International Law. We have selected a collection of important characters and compounds from the Chinese translation and compared them with Wheaton's original text. Our aim is to investigate the translatability of Wheaton's Elements of International Law. To what extent was Wheaton's book accurately translated into Chinese? How was the translation affected by the traditional Chinese culture and traditional Chinese ways of thinking? And in this paper, we have taken relevant parts of Hatsumi Nakamura's ways of thinking of Eastern peoples as the framework of our analysis of the translation. Nakamura's observations of the traditional Chinese ways of thinking are based on an in-depth comparison between complete Chinese translations and original texts of Indian Buddhist scriptures. Nakamura has provided numerous insights to the traditional Chinese ways of thinking. However, due to the different ideological emphasis and exegetical skills used in religious and legal texts, we will only refer to three particularly relevant observations by Nakamura. And the first one is concreteness of expression. Nakamura observes that there is an obvious element of concreteness in the Chinese language. Expressed bodies and shapes are often used in phrases to make a description. However, verbs which express change and transformation are undeveloped. He further claims that Chinese thinking has tended to concreteness of expression. In Chinese language, concepts and ideas are expressed in a highly concrete form. It is evident that the goal is to express things by individualization and specification rather than by analysis. The second observation by Nakamura is known development of abstract thought. Nakamura claims that there is a known development of abstract thought since the Chinese are little interested in universals which comprehend or transcend individual or particular instances. They thus seldom create a universal out of particulars. The Chinese are fond of complex multiplicity expressed in a concrete form, and they are especially sensitive to the complex variety of phenomena instead of the laws and abstractly conceived unity of things. Nakamura further claims that for expressing abstract thoughts, the Chinese language is an awkward medium, and ancient Chinese philosophies were usually expressed in a figurative and intuitive way. The Chinese tradition was weak in the formation of objective laws since the Chinese were not interested in canonical formula. And the third observation made by Nakamura is the anthropocentric attitude. According to Nakamura, the Chinese have tended to adopt an anthropocentric attitude towards all things, and they tried to understand all things, including abstract ideas in relation to man. As a result, most of the Chinese customs and habits are based on practical and utilitarian common sense. Traditional Chinese philosophical studies also focused on subjects which are related to everyday life, such as morals, politics, and worldly ways of living, which would lead to success. And Nakamura claims that metaphysics was underdeveloped in China. Then we will proceed to the part of close textual analysis of the Chinese translation of Henry Wheaton's Elements of International Law. For this part, we have chosen words or compounds from the Chinese translation, which we consider are elementary and fundamental in Western international law. Some of the translated terms are retained and still in use today. Hence, we think it is important to understand how these terms were initially translated or constructed. We'll point out the inaccuracies and inadequacies in the Chinese translation and ascertain whether Wheaton's Elements of International Law is translatable. So the first character that we would like to share with you is the translation of law. Law was translated as fa in the Chinese text. That is the biggest Chinese character on the slide. And this translation of law as fa is still in use now. This translation may not seem to be problematic to a modern Chinese reader who is accustomed to the Western meaning of law, and also due to the fact that we Chinese have used this translation for such a long time. However, the Chinese translation of law was likely to be confusing to a Chinese reader in the late Qing period. Yan Fu, a famous late Qing Chinese scholar and translator, commented that in Chinese language, right and wrong of things is called li, that is the first smaller characters, and prohibitions imposed by a state is called fa, that is the translation of law, whereas Westerners name both concepts as fa. Law in Western language can actually be translated into 4 different Chinese words, which are listed on the slide. That is li, fa, and zhi. And Yan Fu reminded the scholars to be aware of these differences between the 4 concepts. In short, Yan Fu pointed out that the concept of law in the Western legal culture can actually include 4 different Chinese legal political concepts. That is li, reason, right and wrong, li, rights, fa, punishment and prohibitions imposed by the state, and zhi, system and regulation. And according to Shuowen Jiezi, which is an authoritative ancient Chinese dictionary, the word fa is equated to punishment. Therefore, the Chinese translation of law into fa would only mean punishment and prohibitions in the Chinese legal political tradition. The Western conception of law was an entirely foreign concept in Qing China. The meaning of law could not be equated to any single Chinese character. By translating the Western law as fa, the Qing Chinese might have received international law primarily as imposition of prohibitions or restrictions on international relations. And this inadequate translation of law also reveals that there is a huge gap between the Western and Chinese legal political cultures, even on the most fundamental concepts of law. There was no systematic treatment of law as distinct form of morality in the Chinese legal culture.
So now I'll go on to the title of Wheaton's book, which is Elements of International Law. And the title is translated as 万国公法 in Chinese. International law is defined in Wheaton's book, and he says, international law, as understood among civilized nations, may be defined as consisting of those rules of conduct which reason deduces, as consonant to justice, from the nature of the society existing among independent nations, with such definitions and modifications as may be established by general consent. As seen from this definition, there seems to be a shift from the classical concept of international law originating from natural law to a more positive view of law established by general consent. And this emphasis is less on moral being or reciprocal obligations, but more on the latter consent. 万国公法 literally would mean public law for 10,000 nations. 万国 has the meaning of the world and various countries. And 公法 has the meaning of state law or international law. The character 公 itself also carries multiple meanings, including common, public or collective as opposed to private, and belonging of the ruler. Although 公法 can mean public law, and a modern Chinese reader is likely to have such an understanding, we believe that a Chinese reader in the Qing dynasty would be unlikely to have the concept of public and private. This does not only refer to public and private law, but also the public and private realms in the Western sense, because there was no protection of the private realm by the law or other mechanisms, and what was allowed in private was that allowed by the emperor. And there was no idea of the private individuals being protected by the law as against the government, and we think that there was definitely no notion of a limited government. Further, besides what Maranatha has said about law, it would seem that law would mean state law only to the people, and it seemed to be difficult for them to comprehend a difference between private and public law. This ambiguity of the word gong was noted but not addressed by the translators, as they considered a compound appropriate for rendering all of the three terms: the law of nations, positive law, and public international law. The ambiguity and multiple possible meanings of gong is problematic. In the translation, the distinction between gongfa and xingfa, which is the translation for natural law, is not clearly made. There is also not a new term created to represent positive law. As we argue that there was no commensurability of the concept of positive law, when gongfa was brought into China, it may have been viewed as natural law, given the strong natural law flavor in the translation. Some have argued that 万国公法, strictly speaking, only reflects the notion of the law of nations in chapter 1, but not the later term of international law. And perhaps due to the ambiguous and unneutral nature of 公法, this term is no longer in use in modern Chinese legal writings. Rather, a new term, 国际法, was brought into China in the early 20th century after Wheaton's book was translated in Japan. And the use of 国际法 has been established in China since the 1930s. And now on to the translation of natural law. Natural law is translated as 刑法 or 礼法. The classical Western view of natural law has a very strong Christian basis, and it is a philosophical concept derived from the classical thinkers, for example, Grotius. And in Grotius' idea of justice, there is the metaphysics of an independent God. Natural law is translated as 刑法 or 礼法 interchangeably by Martin. And because of a lack of direct equivalence of natural law in the Chinese perception, the translators aim to build commensurability by fusing Western natural law thinking with two Chinese thinkings, the Taoist Tian Dao thinking and Neo-Confucianist Xingli thinking. This move was strongly reminiscent of the 17th century Jesuit strategies of promoting Christianity by reconciling Confucianism and Christianity. A common technique that they employed to make the translation more acceptable was to internalize the text and to adjust it to adapt to the Chinese mindset so that Western norms could be transmitted into China more easily. In Tian Dao thinking, thinkers believe that the operation, occurrence, and development of the nature are natural. There is no other institution which dominates or administers the nature. And as seen from this outset, Tian Dao thinking seems to be very similar to that of natural law, except that God is absent from the picture. Neo-Confucianism, on the other hand, is a combination of Confucianism and Buddhism or Taoism. It consists of the self-reflection and self-consciousness of Confucianism, as well as the external stimulations and enlightenment of Buddhism and Taoism. And through self-reflection, one develops creative and innovative thinking. This fusion of Confucianism and Buddhism or Taoism is Neo-Confucianism, and it was a very popular thinking since the Song dynasty. Neo-Confucianism consists of two important concepts, which is Xing and Li. These two concepts are used interchangeably in the translation, but each of them actually has distinct meanings. Xing, which is the one on the top, has a meaning of natural instincts, life, as well as true nature from Buddhism, while Li, the one at the bottom, has the meaning of reasons. Together, Xing Li also has another meaning, which is the meaning of the principle and discipline of life, or emotions and reasons, as well as humanity and justice. And it is the last meaning, humanity and justice, which is the crux of the Neo-Confucian idea of Xing Li. And a Qing reader was likely to equal Xing and Li in the translation with Neo-Confucian thinking. As seen from this philosophical context, Xing Li has a very different cultural background, which was created by a fusion of multiple philosophies. Xingfa, as read in light of Neo-Confucianism, may have a slightly altered nature as well as added meaning to natural law, which has a totally different religious tradition. Hence, some argue that Martin's translation has transmitted the meanings of both Gongfa, the translation for international or positive law, and Xingfa, the translation for natural law, to somewhere in between the traditional meanings of the two languages. The neologistic use of the two compounds takes Xing and Gong out of their philosophical context. At the same time, it also takes natural law and public law out of the traditional Western legal discourses. So arguably, the translation has created a textual and cultural limbo. Now on to authority. Authority is translated into Jun, which has the meaning of sovereign, ruler, and emperor. In paragraph 1 of chapter 1, legislative authority, judicial authority, and legislative power have all been translated into emperor. This translation is a very concrete and anthropocentric expression and transforms the abstract concepts of legislative and judicial power into the physical emperor. It also seems to corroborate Nakamura's argument that there is a non-development of abstract thought in the Chinese language. We believe that this translation is because there was not an equivalent concept of authority in the Chinese mindset at the time. Up till the Qing dynasty, the emperor in China had taken absolute control of the country, and there was no concept of the legislative or judicial power in the Western sense, since all was under the emperor's rule. The branches which made law and adjudicated cases were seen more as being parts of the central government. They were more like governmental departments and tools to effect the government's administration, rather than separate branches limiting the emperor's power. Although Martin has introduced concepts of legislature and judiciary by neologisms in the later chapters, because of the mistranslation in chapter 1 and the inconsistency of the translated terms throughout the text, the translation is likely to be ambiguous and confusing to a Qing reader. And without offering any explanation to the neologisms, the translation seems to have failed to introduce the fundamental Western governmental concepts of legislature and judiciary into China. And a Qing reader would also easily think that emperor power without any limitation is a valid and legal concept in international law. Individual in the Western context is a concept opposed to the public. And an individual has private rights, and these rights should be protected by the law. This is a core concept of Vattel, that human lives are equally natural and free, and laws that regulate states are seen on the same basis as law regulating individuals. Individual is also an important concept in the unequal treaty signed by China. The basis of the West attacking China was that China should treat all states equally, and China had no reason to refuse to trade with the West. Hence, in the treaties, China had to agree to treat each state equally on the basis that one should treat each individual in the same manner. In Martin's text, individual is translated to 人人. 人 in the singular form has traditionally means human being or person, and 人人, which is the plural form, means people or everyone. 人 also has another meaning, which is common people, and it is another example showing the anthropocentric attitude of the Chinese. Also, the translation of individual showing into human is a very concrete expression, and it again seems to corroborate Nakamura's argument that there is a non-development of abstract thought. However, the translation does not carry the same meaning and tradition of an individual as the West. Here, 人 only has the meaning of human as opposed to animals, or common people as opposed to the ruler. But it does not really bear the meaning of private persons, and there is no conveying of the concept of individual rights. As argued, this is because there was no idea of the public and private spheres in ancient China. There were only the emperor and his subjects, and there were no equivalent concepts of individuals and individual rights. Subjects were bound to obey the rules of the emperor, and there was no notion of possessing something in private unless allowed by the emperor. The law was not to protect individuals, but more like a tool for the emperor to maintain order and rule the country. The implication of the lack of equivalence of the concept of an individual is that the Chinese may not have any understanding of the reasons that the West offered for imposing the unequal treaties on China. All they would know was that because they lost in the war, the winning states could do whatever they wanted against them. This probably also underlies the thinking of the Chinese government until the present day that nothing is more important than building a strong and powerful country.
And then I will talk about the translation of rights in Martin's Chinese translation of Wheaton's book. Although Western legal philosophers have proposed different conceptions of rights, it is undoubted that right, the concept of right, is fundamental to the Western legal culture. In general, the concept of rights defines the content of Western laws. Rights recognize certain actions and institutions as just and proper. The concept of rights is also important in international law. For instance, in Grotius' theory, the only justification for war is the enforcement of rights. The Chinese translation of rights as 权利, read in a horizontal way, so 权利. The Chinese translation of rights as 权利 is an invention by Martin. To translate the word right, Martin used a compound of two Chinese characters, 权 and 利. The Chinese meaning of 权 is power, and the meaning of 利 is wealth. It is clear that the translation of right as power and wealth departs greatly from the Western concept of right, which has the background of restricting the powerful and the wealthy. However, it must be understood that it was very difficult to translate the word right into Chinese language, as there were no Chinese concept or word which could be equated to right. Ancient China did not have the Western concept of right or duty. The Chinese only had the Confucian concept of mean. In English, literally, that would be name and identity, and fen, that would be shares. The Book of Rights stated that according to the different mean, that is rights, is different. Rights, R-I-T-S, rights is different. That means the identity of a person would define is his rights and his ethical or appropriate conducts. It is clear that Min and Fen cannot be equated to the Western concepts of right and duty, and this tradition of Min and Fen was only a cultural moral responsibility and was not sanctioned by the law in the Chinese culture. In the Chinese tradition, there was also an ideal of no conflict. For example, when civil disputes arose in ancient China, the most important thing to the Chinese officials was not to define the rights and duties of the parties, but to try their best to dissuade the parties to pursue their claims. It seems obvious that the Western concept of rights would create many conflicts and would not advance the Chinese ideal of no conflict. Hence, it is understandable that it was not an easy task for the Chinese to understand or accept the concept of rights. Martin's choice of the characters Chen, power, and Li, wealth, as the Chinese translation of rights might be influenced by the natural law tradition. The reason of choosing the word Chen, power, might be an attempt to convey the meaning that right is a moral quality of a person, making it possible to have or to do something correctly, and that right is a capacity or power possessed by the agent, and also a faculty or an aptitude of the person. And the choice of the word Li, wealth, might be an attempt to convey that rights can bring benefits to the relevant rights bearers. However, as mentioned before, due to the existing meanings of Chen and Li as power and wealth in the Chinese language, as well as a total lack of conception of rights in the Chinese culture, Martin's translation would likely confuse a Chinese reader in the late Qing period. It should also be noted that the translation of rights into Chen Li, power and wealth, is turning the abstract idea of right into a more concrete and figurative form of expression. Although it might be explained that Martin was influenced by the natural law tradition, Chen Li, power and wealth, is still a somewhat awkward translation. However, this Chinese translation of right is still widely in use today in China. And then I will talk about the translation of sovereignty and sovereign states. Sovereignty is an essential concept in international law. Historically, the international community was seen as a system of sovereign states, and this view was confirmed at the Peace of Westphalia in 1648. Philosophically, international law jurists such as Grotius and Vattel affirmed that sovereignty is fundamental to states, as well as the system of international law. For example, Vattel wrote that a nation or a state is a body politic. It is necessary that there should be established a public authority to order and direct what is to be done by each in relation to the end of the association. This political authority is the sovereignty, and he or they who are invested with it are the sovereign. Sovereignty is translated as 主权 in Chinese, which is also an invention by Martin. In the ancient Chinese language, 主权, that is the two characters on the left on the slide. In the ancient Chinese language, 主权 as a compound had two meanings. The first is the authority of the ruler, and the second is officials who control certain authorities or power. If we look at the two characters separately, 主, the first character, literally means direct, dominant, and lord, while 权, the second character, means power. On the other hand, sovereign states is translated as 自主之国. In English, literally, that would be self-directed state. Sovereignty was undoubtedly a foreign concept to the Chinese in late Qing period. In the Chinese history and culture, as the famous Chinese historian Xu Zuoyun points out that the old Chinese world was a conglomerated cultural system, and international actions were regulated by cultural values. It was not an international community involving many sovereign states. That was an order of rites and rituals, not an order of law. It seems that Martin's translation of sovereignty as 主权 is a decent translation which is able to capture the core meaning of sovereignty. The translation is able to convey the meaning that sovereignty is a supreme political authority within a certain territory. According to Vattel, a sovereign state is a nation that governs itself under what form soever, without dependence on any foreign power. Its rights are naturally the same as those of any other state. Such are the moral persons who lived together in a natural society subject to the law of nations. To give a nation a right to make an immediate figure in this grand society, it is sufficient that it be really sovereign and independent, that is, that it govern itself by its own authority and laws. It can be noted that sovereignty, being an abstract concept, when translated into Chinese, is expressed in a more concrete way, 主权, the power of self-direction, or 自主, self-direct, are descriptions of the core quality of sovereignty. That is, a sovereign state can be its own master, its own lord, who can direct its own conduct. We think this is a kind of figurative specification of the abstract idea of sovereignty. This Chinese translation of sovereignty also shows the anthropocentric attitude of the Chinese people, because they tried to understand the abstract idea of sovereignty in relation to man, in relation to what a sovereign state can do to itself. And then I will talk about the translation of independence. According to Vattel, independence is an essential quality of a sovereign state. Interestingly, independence is also translated as 自主, self-direct. It is the same translation as the translation of sovereign. This overlap is shown on the slide by the red characters. Such overlap is unsatisfactory because it is clear that the concept of sovereignty cannot be equated to the concept of independence. In Martin's Chinese translation, an independent moral being, which is a phrase describing a sovereign state, is not properly translated. The whole sentence in English was, every state has certain sovereign rights to which it is entitled as an independent moral being. In other words, because it is a state. The corresponding Chinese translation is shown on the slide, and the literal English translation of the Chinese translation would be, a state is a state because it is self-directed and it has righteousness to be observed and power to be used. To be more specific, an independent moral being is translated as the red words on the slide, and in English it is translated as the state is self-directed and has righteousness to be observed. On the one hand, a reader might be confused by the 自主, self-directed, because as mentioned before, 自主, self-directed, is the translation of both independent and sovereign. Here, both the words sovereign and independent appear in the original English text, and it is particularly ambiguous and confusing whether the Chinese words 自主, self-directed, means sovereign or independent in this context. On the other hand, the word moral being, which means a body politic capable of enjoying rights, is not directly translated into Chinese. Rather, it is translated that a sovereign state has righteousness to be observed. Moral being is a very abstract idea, and here we can see that the Chinese translation fails to communicate this idea properly. Further, the fact that sovereignty and independence are translated into the same compound shows that the incapacity to translate sovereignty in an abstract way creates further confusions when other abstract concepts are also expressed and explained in Chinese. As mentioned before, while 自主, self-direct, is indeed the core quality of sovereignty or a sovereign state, such translation is a concrete description of the actions that a sovereign state can do. This non-abstract expression may not be a problem when we evaluate only the Chinese translation of sovereignty. However, when we look at the translations of sovereignty and independence together, we can see that the non-development of abstract thought and usage of concrete expression blur the distinction between different abstract legal concepts. This is unfavorable to the development of legal analysis because legal analysis requires great caution in distinguishing different abstract concepts. As mentioned in the beginning of our presentation, Nakamura observes that when the Buddhist scriptures were translated into Chinese, many of the original meanings and concepts were altered and distorted during the translation process. At the same time, such alteration and distortion also revealed the Chinese patterns of thinking. It seems that a similar observation can be made in relation to Martin's Chinese translation of Wheaton's Elements of International Law in the late Qing China. In our research, it is found that in Martin's Chinese translation did reflect the Chinese ways of thinking, as suggested by Nakamura, which prefers concreteness of expression, non-development of abstract thought, and an anthropocentric attitude. As demonstrated by the translated words that we have analyzed, these Chinese ways of thinking are unfavorable to further understanding of Western legal concepts. This is because Western legal culture emphasizes and requires a high level of abstraction, formation of objective concepts and laws, and creation of a universal from particulars. However, it must be noted that we are not trying to say that the Chinese ways of thinking are inferior to that of the Western world. We are just trying to point out the incomparability and incommensurability between the two cultures, which becomes especially obvious in the context of international relations and order. Therefore, we suggest that the incommensurability between the Chinese translation and original English text seems to have gone beyond the differences between the two languages, and it's actually a matter of culture.
So we think that the problem of the translation is the failure to transmit Western legal concepts into China. Associate Professor Su and Lecturer Fu from the China University of Petroleum argue that in order for legal translation to be deemed successfully transmitted, there must be internalization of the legal concept in the receptive country. The foreign legal concept has to pass a period of rejection and becomes an integral part of the local legal system and be used by the local people as local law. In order for internalization to take place, legislature of the receptive country has to understand the translation. Local circumstances, including social, economic, and legal culture, have to be reformed for the new translation to be implemented. The different cultural background between the two states have to be identified in order to build the circumstances necessary for the translation to be understood and implanted. Xu and Fu note that legal documents and legal rules are cultural texts, and so legal translation must also be cultural. Hence, legal translation must be accompanied by the necessary linguistic culture and environment. Otherwise, traditional meaning will be lost in the translation, and this is the cultural fill or thick translation. We believe that this cultural gap was the main problem when Wheaton's text was brought into China. When the translation was conducted, the West already had more than 200 years of common law development, while China had been in 2,000 years of autocratic politics and legal culture. The legal tradition, background, and culture of China and the West were very different. With this cultural gap, we think that Martin's translation has failed to create any internalization in China, and we argue that such translation without any explanation would be incomprehensible and not understandable to a Qing reader, and this loses the whole meaning and value of translation. Before the translation of Wheaton's book, basic notions in the Western legal culture such as individuals, rights, and sovereignty could find no equivalences in the Chinese culture. For many Chinese officials and intellectuals, these terms were totally unheard of. The incomparability of the Chinese and Western approaches to social order could not be easily shaken, and hence we argue that the incommensurability of the languages is only at the surface of the problem, and its root actually goes down to the clashes of the two very different and conflicting cultures. And so to conclude, we argue that Martin's translation did not cause any internalization of Western knowledge and Western norms. The distinctive Chinese understanding of international order arguably still remains, And with China's continuous rise in the 21st century, the Chinese conception of international community may act as an alternative or even challenge to the traditional Western perception of international law. So this is the end of our presentation. Thank you.
Thank you so much to both of you, Emily and Maranatha. Officially, we are running out of time, but I think we should take some time for questions and answers. Let me look around the room. Yes, please.
Thank you for the novel presentation. My question is that we're talking here about elements of international law. It's a conversation between states, not between the state and the governed. Yet, you analyze the translation according to your conception of national law, not international law. Therefore, your translation of law is that between the state and the subjects of that state, not between state and state. So I don't see how there can be a mistranslation by Martin of Wheaton's elements. Your concept of sovereignty, for instance, you criticize it as one which is not in accordance with your understanding of sovereignty. But basically, Martin's translation is about sovereign state in an international context, in an international system, not in a domestic system. The same with your conception of right or conception of law. You cannot have an international law defined as a grant of right to a state. Certainly, it is international law as a restraint, a prohibition on the state, rather than a grant of right or obligation or prerogative, etc. Thank you.
Thank you for your question. And actually, I want to clarify your question. Are you asking us why do we choose these words, which seems to be more related to, or you mean our interpretation of the words are more in the context of national law than international law?
I'm asking why you take the perspective of national law to analyze a translation of international law. These are completely separate systems. We are talking here about law between states, not law between the state or the government and the governed. Therefore, you would have different conceptions of those legal systems. Second, you're talking here about a translation to be used not by the ordinary Chinese, but by the diplomats who are negotiating on behalf of their state. So the language used would certainly be about restraint on sovereignty, about independence, autonomy, about restraints on the power of the state. You cannot be talking about the grant of right, the grant of privileges, etc.
Yes. Thank you for your clarification. First of all, we have to talk about a bit about the historical context of the late Qing China, because at that time, Chinese did not have the concept of international law at all. Therefore, that is why when we interpret the translated words in Martin's Chinese translation, we took a more national law point of view, because that is exactly what the Chinese at that time would think, because they didn't have the concept of international law or international order in the Western sense, or even arguably national law in the Western sense. So this is the first point. And the second point is that our choices of the words and our interpretations of the words we actually referred to a lot of ancient Chinese texts, and some of the writings of the Chinese officials at that time and to ascertain their understandings of those words and how do they understand the meanings of those words. So
Perhaps I'll just expand a bit on the international law point. Our main argument is that Chinese people at that time did not really have the concept of international law or international community because, and they mainly see, at that time, the tributary system has a very strong influence in China. And so the people actually see states like family. And they expand the notion of the tributary system within the country to international order. And so I think this is why we analyze their understanding of international law from the national law perspective. Anything to add?
I find your presentation very interesting. This is just my one-cent question. If the Spaniards have the Victoria, the Dutch, Grotius, Vatel with the French, is there an equivalent scholar for the Chinese? And in what sense can we say that there is already an internalization of international law as far as the Chinese are concerned?
sorry, can you repeat your question? Sorry.
Sorry, because we are dealing in a sense with international law, and we are trying to have some form of a dialogue, okay, between the East and the West, so that the Western tradition, okay, we have, of course, as mentioned by Professor Carty, who was also my professor. You have the Victoria for the Spanish, Vatel for the French, Grotius for the Dutch. In the Chinese context, do we have an equivalent? And up to what point did you see an internalization of international law as far as the Chinese are concerned? Did it begin with the 1945 UN Charter, or even prior before that, or was there a shift from the Qing and then with the coming of Dr. Sun Yat-sen?
Thank you for your question, because as we have mentioned, the ancient Chinese community did not have a concept of international law as in the Western sense. So I think there is no equivalent figure, legal figure, like Victoria, Grotius, or Vatel in China, because the whole concept of international law or international community or like sovereignty or rights or sovereign states are totally foreign to the Chinese in the late Qing period. So actually they did not have any comparable legal scholars who can be compared to these like Western jurists.
Well, I don't want to appear to be rushing to the defense of my hardworking students, but I do intend to do it anyway. I mean, I don't really see where Melissa and yourself, Herbert are coming from, because the concepts are basic jurisprudential concepts of sovereignty, independence, of right, law, especially natural law. These are very basic concepts coming from Western culture, which have philosophical abstract implications. And as I understood it when they presented this to me for the first time in the class, it was an eye-opener to me, because the Chinese words that were being chosen were material and concrete and had no necessary normative implications at all. And that is how I read what they were saying. And so I'm not awfully sure what the point of asking whether this is whether they're talking about domestic law or international law, because they didn't have any domestic law either. They didn't have a constitution. There wasn't a constitution either. They only thought of having something around 1905 or 1906 to have a domestic, which immediately collapsed. Yeah. So my basic point is the way I read this subjectively is that the point that the two ladies were making when they presented these arguments to me for the first time is that abstract Western concepts like norm, right, state, sovereign, they were all being translated into very concrete empirical notions of power, and that was simply becoming something else. It was neither domestic law nor international law. I mean, China had no more domestic law than it had international law at this time. That's just my kind of instinct or feeling about what I'm saying.
I would just chime in here just to point out a similarity, and this is where, the comparison is really, what they're talking about here is effectively the same process that the legal humanists did for the European case in the 16th century. They use local terms and ideas in order to translate or come up with a language for international or the law of nations. And so what I actually see here in listening to this and also in thinking about your questions is it's actually the method or the process of kind of making something your own by tweaking it and then putting it back out again. And in this respect, this seems to me, there is no, there is a jus gentium before Vittoria. And before this process comes, which we talked about, this seems to me like the really significant point at which you start having a kind of ownership or a kind of an internal understanding of these concepts outwards. And so there's not a single great figure in the Western tradition that marks the absolute beginning any more than it seems like there's a single great figure in the Eastern tradition that marks the absolute beginning. But then these work out over time with different traditions. Is that a fair way to kind of think about the comparison?
Mm-hmm. Thank you.
Either way? Or are there, you want to respond?
Yeah, I think the main reason for us to sometimes it's difficult to understand to comprehend the comparison between the Chinese and the Western legal cultures. It is because of the fact that they are just so different. Like we are Chinese and we receive Western legal training, and we still find it difficult to compare the two different legal cultures. So I think maybe it's hard to imagine that China having such a long historical culture, but have absolutely no tradition of national or international law as in the Western sense. Yeah.
And I think regarding the translation process, I think it's a common method that translators employ when they try to translate something that has no equivalence in the receptive country, and they try to mix it with something of their own. And so actually what we try to argue is that the translation has kind of take it out of the traditional Western context as well as the Chinese context and create something in between. Yeah.
I just want to add, I mean, this process is so comparable because, like I'm saying, you can't make the equivocation of the periods, but in the same way, the Europeans took something that was outside of their tradition, a Roman tradition, and made it their own by bringing things internally and translating the language in a new way. So I see that, there's a 500-year difference, right? But it's the process is comparable, which tells us something about the way that these just the universality of how you actually can make something your own and then turn it back out again. I mean, I'm not saying they're the same. I'm saying that they're comparable because the context, the problem of translation and reinvention and the creation of a legal language that you can use is very comparable here.
Well, thank you.
Yeah, I see hands. Okay, yeah, I'll come back to you. Do you want to respond first?
Yeah.
Okay. Okay, then that's the right order. Very, very helpful. Thank you.
Yeah. Professor Carter refuses to see the point I made, but let us be concrete. In your critique of the translation of the word law, international law, you said that the traditional Chinese concept is that of a definition of a right, a privilege, etc., whereas Martin's translation is that law is a prohibition. Let us say that Martin used the translation that you desired, which is grant of a right. Would it have favored China in relation to Western imperialism to have viewed international law as a grant of a right by the Western imperialist colonial powers upon China? Or would it have favored China to use the concept of international law as a restraint on the Western imperial powers? That's the entire point of making. You cannot translate the elements of international law by using it as elements of national law. And therefore, your conclusion is not justified.
Maybe firstly, what Professor Carr just said about like the translation. First response to Professor Carr, like the translation always like apply local language to transmit the meaning of some terms. I think for specifically for late Qing China, I think for Martin, because he was the guy who spent quite a long time living in China. I think one of the reasons why he applied some Chinese culture, for example, some Confucianism into presenting Western legal terms to the Chinese officials, is that he knew very well about Chinese culture, is that they always go back to their history to find whether they can like found some old practices in their history which is similar to the new things they're going to accept. So I think that's the way maybe Martin intend to try to apply some Chinese Confucianism to compare it with the Western natural law, to persuade the Chinese officials to accept Western international legal system, to show that you can see there actually are a lot of similarities between these two systems. So which can make the Chinese Qing officials make more secure to accept this totally new legal system. So I think that might be another possibility why Martin apply some local like culture or Chinese culture in translating the Huiton's international law books. That's one comment. And for Melissa's comment, I think that when you said when you mentioned the national law and international law thing, I think you are still like taking the Western approach to look at the Chinese perception of international law, because just like the speakers said that before, because the Martin's book is the very first one which show the whole picture of the Western international law to China. So before that, China didn't have a relatively complete understanding of Western international law, not sovereign states, not international law. Maybe you can have some like understanding of Zhao Tingyang's philosophy, Tianxia system, which is more similar to Chinese philosophy, because Chinese culture, they don't really like separate domestic affairs from foreign affairs. I mean, in their cultures. For example, the tributary system, even though they have foreign countries and their own national interests, but they don't use sovereignty states, this kind of definition to define states. They just put states into different categories according to how close the relationship between those states and China. So So for Martin, it's the first time he tried to translate the totally new legal system to China. So it's really difficult for China to distinguish between the so-called national interests because they don't have the definition of sovereign states, right? So it's too difficult for them to understand or to put the sovereignty states definition into the circumstances of the so-called international system.
I can just quickly respond. Regarding the restraint point, I think even in Maranatha's explanation of restraint, it has a different meaning in the Chinese language with the Western language of restraint. In domestic law or domestic order in China, I think the restraint or the law is more like a governmental tool of the emperor only, rather than, and it's punishment and it's quite arbitrary by the emperor rather than a very systematic legal system. So I think still that is slightly different. And regarding the fusion, the comparing of Confucianism and the Western legal system, another reason why Martin fuses Neo-Confucianism and his translation is that actually he wants to include more, he wants to promote Christianity into China. And this is a purpose that many missionaries had at that time. And it's a common technique that they used. They try to, because they see some similarity between Neo-Confucianism and Christianity. So they try to fuse the two together to actually try to promote Christianity into China. So this is also one of the purposes. And yes, regarding the tributary system, I think, yes, I agree, because at that time, China would see other foreign states just like how in the tributary system, the relatives have different proximity with the emperor. So they will see the whole international community like a family. So the closer countries or countries which have a better relationship with the emperor will be seen as closer countries. So they differentiate states in categories and in such a system.
Yeah. Good. Well, kind of question or comment here. I mean, this is a very, I know this is, I'm defending my students here. This is a, I don't know, 15 or 20,000 word paper, which goes through an awful lot of different words and is more positive about the success of the translation of some words than others. So there isn't an overall thesis that the whole thing is untranslatable. Some words are more translatable than others. But what hit me, I would take one example here. What hit me, and this is where I'm coming from, I think this is, I'm being quite openly subjective about this. The translation of the word right by Quan and Li. So this is an example that they actually presented to you. So you have it. It's not just something that's in their paper that they didn't present. It's Quan Li is power and wealth. So they have the notion of right as being associated somehow or other in this translation with power and wealth. Now there is another paper in our contribution by a mainland scholar called Jen Tao, and he is the he's a historian in Shenzhen University, and his thesis is the whole, and this is also discussed in the implications section of the paper by Emily and Maranatha, that the Chinese actually understood international law collectively, the intellectuals and the officials, as an imposition of power. That they couldn't internalize as meaning anything that obliged them. And that was fundamental to the collapse of the whole Qing system and to the whole attitude to law and international law that has come after that. And so to me, I mean, I'm just I'm just benefiting from what these two ladies have come up with here linguistically, which I haven't found anywhere else. That, I mean, it's making sense in a way, this Chinese reaction to the nature of international law, that these concepts like right are being translated, power and wealth. To translate right as power and wealth is totally to retranslate something that we regard as good into something they regard as bad. And it's nothing to do with whether it's domestic or international. I really don't know where Melissa is from. So this is, it's evocative. Now, what Sarah Susan has said is also terribly important, because Emily and Maranatha are not claiming that all of the translations were a failure. Some of them were more successful than others. And I know, so I look again at the paper, that they think that the translation of the word sovereign, which is a very difficult word in Western thinking, is actually, they think is actually reasonably successful. And the Chinese never stop yakking on about their right to sovereignty. So I think they do know what that means. So just kind of comment.
This afternoon. I won't abuse my position as chair and not torture you with any more questions. Just ask the audience to join me in thanking you again. So thank you all for this wonderful, productive day with a lot of questions and discussions. And I think it's been a long day, so I wish you a restful night and look forward to our continuation of the discussion tomorrow. So thank you.